Those case people versus Guy Brent.
Special Lobby for the People.
Assistant Public Defender Natalie Pate, on behalf of Mr. Brent, who stands to my right. Please state your name for the record, sir.
Guy Brent.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review the PSIR as well as the recommendation from probation. As to the report, we have no material changes or corrections, but my client does ask that I make a brief request as to the recommendation.
All right.
To be candid, Mr. Brent does understand that the court will likely be following the recommendation and sentencing him to probation. That is the case. He is asking for a payment plan as to fines and costs. However, he is respectfully requesting that the court consider sentencing him to time instead of probation. He does understand that he will likely be
Wants to go to jail for a year.
That is the request you asked that I make today, Your Honor. He is willing to comply with probation if need be. However, given the expenses and some of the obligations, he is asking to serve the time instead. He understands, though, that Your Honor will likely adopt the recommendation.
Do you want to go to jail?
No, sir. It was just dealing with probation. Flat.
So you think it'd just be easier if I just sent you to jail?
Well, just the way this probation is just a lot right now. I'm gonna try to complete it, but I got 6-week program for program I'm doing that.
You're doing a substance abuse program right now?
All right, here's where the case takes a turn. This is the moment the defense steps forward, asking the court to consider loosening the current bond conditions. The focus is on Mr. Hopkins, who was once gainfully employed but now finds himself out of work, largely due to the restrictions of his electronic tether. According to his attorneys, he's not looking for a free pass. He's asking for a fair shot at rebuilding. They tell the court he's been accepted into a cybersecurity course, mostly conducted online, but he needs more flexibility to fully participate. Beyond education, the defense stresses that he wants to start earning again, to contribute, to function, and to live like a productive member of society. There are no violations on his record during bond, no evidence of risky behavior. The legal team paints a picture of a young man who made mistakes, but is now trying to correct course, not just for himself, but for his future. Whether the judge sees it that way, though, is what we're about to find out. Let's head back in and see how the court responds. Let's take a closer look at how the defense is presenting their side. They're working hard to reshape the narrative around Mr. Hopkins. According to them, this isn't the story of a violent offender. It's the story of a 20-year-old with no...
So if I send you to jail, what happens to your participation in that program?
I'm not sure. I actually didn't follow up with that. I just talked to her this morning. I didn't talk to...
Your Honor, if I may, I believe he would not be allowed to continue with that program, unfortunately. And I did encourage him to stick with that program and under the supervision of probation.
Tracy Clare on behalf of probation, or Your Honor, with that program that he's speaking of, he is in CCOP. As a condition of bond, he had to be drug testing. He had some issues with the testing, and I think conversation with the agent over there. Given the conversations that they had, they referred him to CCOP, which he has completed the intake and taken that program. That's why it is picked up and adopted with the recommendation to the court.
Thank you.
That is all correct, Your Honor.
I'm still trying to figure out why you want me to send you to jail for a year.
I was unclear that it was a year, but I also have
So even if it were 93 days, why would you want me to do that?
because I have another case on the 11th, and I believe
Where?
think they're putting me on probation for that as well, and so I'm getting a probation. I guess I have 2 probation officers, Cheryl Boyke and Teresa, and
That's
a lot to keep up with.
Your Honor, he has sentencing at 14B on December 11th. And that is for a failed to report an accident.
You're working.
Yes, sir. Probation interview.
You're in a treatment program, right?
Criminal record who found himself in a volatile, emotionally charged situation. They claim it wasn't a one-sided conflict. Instead, they suggest both individuals were involved in the physical exchange, framing it as a mutual altercation rather than an act of aggression. As for the domestic violence accusation, his legal team says it stems from a misunderstanding, specifically, an argument that escalated while Mr. Hopkins was trying to retrieve his own property, namely his laptop. They argue his actions weren't driven by anger or intent to harm, but rather by panic and confusion in the heat of the moment. The defense is clearly pushing to show that this was a regrettable but isolated incident, not a reflection of Mr. Hopkins' character. Now, it's up to the court to decide whether that version holds weight. Let's head back into the hearing and see what the judge thinks. Here's where things take a dramatic turn. The courtroom turns its focus to the key piece of evidence, the video footage. This is the moment both sides dig in. The defense is quick to downplay what's shown on screen. According to them, it wasn't a violent encounter. It was a chaotic scuffle followed by a frightened attempt to flee. No fists thrown, no serious aggression.
Try to deal with some of your issues. Where are you living?
Ypsilanti.
You by yourself?
Yes, sir.
You rent?
Yep.
How long you been in that apartment or that place?
My whole life, 26
Pardon?
years. My whole life, 26 years.
In that residence?
Yes, sir.
Is that somebody else's house or yours?
My mom's here.
What would your mother say if she knew that you were up here asking me to send you to jail?
Whatever the
What would your mother tell? What would your mother say?
whatever, just to get me over with this as soon as possible. Both cases.
So you understand that if I accede to your wishes and send you to jail, then on the 11th, Judge Washington might still put you on probation of some type.
I believe that was just dismissed, and I was just showing up for yeah, that's
Dismissed.
I mean, sentencing was just to follow up with, because I reimbursed the victim, so I understand I played no contest, but from my understanding, the judge that was sentencing me was understood. Guess talked to my attorney and understood that I reimbursed the victim, and of course I couldn't get it dismissed because I played no contest, but you know.
Thrown. No serious aggression. Just a young man caught up in panic. But the prosecution paints a very different picture, and they're not backing down. They argue that what unfolded wasn't just panic. It was an outright assault on law enforcement. They claim Mr. Hopkins punched officers, resisted arrest, twisted an officer's finger, and escalated things to the point where a taser had to be used. At one point, multiple guns were drawn and officers were left injured. It's a scene that quickly moved from tense to dangerous, and the courtroom can feel that shift. What was initially framed as a misunderstanding now looks, in the prosecution's telling, like a young man spiraling out of control. With both sides holding firm, the judge is left to weigh two very different interpretations of the same footage. Let's head back in and see how the court processes what just played out. The judge finally speaks, and her tone is one of deep concern. She doesn't just glance over the details, she pauses, clearly disturbed by how rapidly the entire incident unraveled. What began as a simple push spiraled into a high-speed chase, sirens blaring, multiple officers drawing their weapons, and a young man on the...
I guess I can't say it's gonna get dismissed because I played no contest, but I doubt if I get probation for that one.
So you don't think you can do this probation?
I can't. It's just,
What?
I can't.
Then why do you want me to send you to jail if you know you can?
Okay. I guess I'll just withdraw the request. Sorry.
Your Honor, if I may briefly, we would like to withdraw that request. And I do believe that this recommendation from probation is a good recommendation. And I do also believe that Mr. Brent will follow it and benefit from it. And I do believe that he'll remain in compliance. I know he is a hard worker. He works full-time, 7 to 3 shift at Taco Bell, full-time, been there for a while. And I believe your child is 7 years old, and he just does support a 7-year-old child. I believe he will.
You've got to be kidding me. You have a child?
Yes, sir.
How often do you see your child?
About 4 days a week.
How many?
About 4 days a week.
Girl or boy?
Boy.
So, what's that child think when all of a sudden I don't see daddy at all?
Well, I don't want to get into details of the case, but during the incident of the situation, he was on scene, and like I said, I was just...
No. That's not what I'm talking about.
Ground. Her question is straightforward, but powerful. How did things get out of control this quickly? She openly wrestles with the moment. Was the response proportionate to the situation? Was the level of force truly necessary? And more importantly, are all the facts laid out clearly, or has the truth been lost in the heat of that chaotic confrontation? As the courtroom quiets, the defense sticks to their story. They insist Hopkins panicked. They repeat that he never struck anyone, that he froze under pressure, ran out of fear, not aggression, and stopped as soon as he realized the situation had escalated beyond control. Now the courtroom waits. The judge has doubts. The defense has explanations. But the question hanging in the air is whether the truth is as clear as either side claims. Let's see where this all leads as the hearing moves forward. Once again,
Yeah, you see him 3, 4 times a week, right?
Sir.
So if I send you to jail, how many times are you going to see him a week?
0.
What?
0.
So why would you do that to him?
He witnessed me get taken to jail the day of this incident. Like I said, I was just wrong place, wrong time that day, and I was unaware I had warrants out, so they had to take me to jail. Yeah. So it's not like he hasn't, dealt with it before. It's just...
Young man, do you understand what I'm asking you? How do you do that to your son? Don't care what he witnessed. How do you do that to your son to just disappear for a year? And worst of all, ask me to do it.
I was unaware that it was a year. I understood I had sentenced in February 3rd.
Okay, so let's say it's 93 days. It's not, but let's say that it's 93 days. Why would you do that to your son? You have an answer for me?
I don't.
Pretty stupid, isn't it? I mean, I'll just be blunt about it. It's stupid. I mean, aren't you out there trying to teach him the right way to do things?
Yes, sir.
And if you're not there, how are you going to teach it? I'm going to just say this, and maybe I shouldn't say it, but I'm just going to say it anyway. I do not understand how somebody that looks like me comes up here and asks the court to send me to jail.
the defense makes their case, urging the court to see beyond the headlines and look at the facts. They emphasize that their client poses no flight risk, has no prior criminal record, and hasn't had any contact with the alleged victim since the day of the incident. In their view, this isn't someone trying to run from justice. It's someone trying to rebuild his life. They make a heartfelt push. Let him return to work. Let him pursue his education. Let him move forward. He's made every court appearance without fail, often accompanied by his father, a quiet but powerful show of support. But as convincing as the defense may be, the decision the judge faces isn't about family optics or courtroom manners. At the heart of it all lies a more pressing question.
I've never dealt with probation before. It just became a hassle just due to the prior 3 weeks I've been on it. I mean, I'm compliant, and everything's been running smooth so far, but not dealing with my work schedule. And
Young man, tell you what I want to do? I want to send you to school and make you take a history lesson. Because if you took one, maybe knew a little bit more about your history, there would be no way you would come up in any courtroom and ask to be sent to jail. Anything else?
After the approach.
Yes. All right, we're back on the record in the case of the People versus Guy Brent. Mr. Brent, let me try to understand your living circumstances. Who lives there with you?
I stay by myself.
Pardon?
I stay by myself.
Okay, where's your mother live?
She lives in Detroit, Michigan. She just moved out there December 2023.
So how long has she been out there?
December 2023.
Okay. So how are you seeing your son?
I pick him up from school.
If I may, Your Honor, Mr. Brent, have you been doing that since October 25th, or is this prior?
I haven't seen him since this case, October 25th. I haven't seen him not one time since October 25th.
Hold on. I asked you how often you see your son.
Prior to the case, for about 4 to 5.
Well, you didn't say that to me.
Oh, I thought that's what you were asking.
Powerful show of support. But as convincing as the defense may be, the decision the judge faces isn't about family optics or courtroom manners. At the heart of it all lies a more pressing question. Is this individual a potential danger to the public? And does releasing him serve justice or put others at risk? These are the stakes, and they hang heavy in a room as both sides await the court's next move. And just like that, the gavel doesn't fall, but the decision lands like a thunderclap. The judge firmly denies the request. No changes to the bond. No added freedoms. The tether stays. The restrictions remain. She makes it clear this isn't a time for second chances or flexibility.
Because I was ordered not to do not
tight-
contact. So I can't see him. I can't call him. Nothing for this case.
How often do you go out to your mother's?
I just went for Thanksgiving. Prior to that, I only been out there probably twice.
So you've had no contact with the child?
Yeah. And his mom as well.
Pardon?
His mom as well.
What city does the child live in?
He stays in Ypsilanti.
Tell you what I'm going to do. I'm going to adjourn his sentencing to the 16th. Because some of what's being told to me doesn't make any sense. And I'll explain some of it afterwards. And Ms. Polaire, I may need you to look into something else.
Can I help you clarify?
I don't think you can.
Oh.
Um,
Trying to figure out my living situation.
well, maybe this. How often does your mother see your son?
Now since this case, a little more often. Used to be probably once a week. Now it's probably 3-4 times a week. She's filling my shoes, so.
What I'm going to do is I'm going to adjourn the sentencing to December 16th, 2024, 1 p.m. And then talk about what I need to check into Miss Blair. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Hold on a second. Who's there with him? So, yes. His grandmother? Not his mother. Your grandmother lives here?
She stays in Ann Arbor.
Okay, we'll figure it out. Thank you.
Mom, can I go?
Huh? Oh yeah, you're.
You say it, I gotta go.
What'd you say?
He said I'm coming.
No, you're good. I was just trying to. I'm trying to figure out the dynamics of everything, and then I saw you, and I was trying to figure out who you were.
Or flexibility. But she also stops short of tightening the leash further. The bond amount holds steady. No increase, no dramatic escalation. It's a calculated pause, like she's bracing for what's to come. The judge points to the upcoming preliminary hearing as the real moment of reckoning. And then, with pointed clarity, she delivers a line that quiets the room. By rights, I should remand him. Her voice is calm, but the message lands with weight. You can feel the tension in the room tighten. For now, Hopkins remains out, but barely. He's not walking free. He's walking on thin ice. The courtroom may be quiet for now, but this storm is far from over. Let's see what happens next.